Hill Yacht Club, which is 2022-11-010, Watch Hill Yacht Club. Application dredging of 765 cubic yards of sediment from Watch Hill Cove within the marina's MPL, marina perimeter limit, and the beneficial reuse disposal on the Watch Hill Beach, located at plat 185, lot 31-1, 1 Fort Road / 151 Bay Street, Westerly, Rhode Island. Just the parties for the Watch Hill Yacht Club present. I see individuals before me. Do you want to swear them in?
Mr. Parks, why don't you identify yourself first?
Hi, good evening. Joshua Parks, I'm an attorney representing the Watch Hill Yacht Club. And I have with me here Jeffrey Livingston, who's part of the leadership at Watch Hill Yacht Club, as well as Anthony Mena, who is the engineer who prepared the application.
Gentlemen, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
You do.
Please, and your names have already been stated, but can you spell your names for the record?
N-E-N-N-A, Mena. Livingston, Livingston.
And I expect staff may present, and if it's all right with the council, I'll have Mr. Livingston just talk very briefly about the yacht club and its history and use, and Mr. Mena discuss the substance of the application, and I'll reserve comment until the end of public comment. Again, if that's all right.
Okay, it's fine. All right, Justin, you have this one, please.
So we're talking about tonight is that this project is a dredge project for the removal of approximately 765 cubic yards of material from the Watch Hill Cove inside the Watch Hill Yacht Club's marina perimeter limit. This will be on the interior portion of Watch Hill Cove. It's got a Watch Hill Yacht Club's got a building that extends into the water, is elevated. This will be the internal side of that on the within the west and east side. This material is planned to be removed by mechanical means, dewatered onshore on what is the Watch Hill Fire District's land, and then once dewatered will be reused beneficially on the local Watch Hill beach, right around the corner there. This is a similar project that has been done in the past, once in 2007 and once again in 1998. This is, has been done before. We consider this a good project with considering use, with beneficial reuse. Is also needed as the current level of sediment is impeding certain performances of the marina, including limited slip space and preventing access to utilities of the dock that run to the main building. There's no variances requested for this permit. However, it did receive several objections. Two main categories are environmental impacts and relations to the Fort Road, right? Fort Road. And incorrect material, the public notices, and so on. I will go through those. Environmental impacts were related to impacts to horseshoe crabs and among other fish. Considering this project is going to be done during the dredge window season, which is off season for both hermit crab egg laying, horseshoe crab egg laying, and other fishes. That's usually considered what we consider a very mitigating circumstance, and will relate to less impact of the area. There's a lot of similar habitat nearby. The habitat in general is the same, just reducing the level will not change significantly the area's use for local habitat. And no toxic material was found during any sampling or has been found in the past. This is kind of a well-known material. Most of it comes from the dunes adjacent to the area, flies across the parking lot and accumulates into the water, which is why it's good for use on the beach. It's pretty much the same material. We received a couple of objections with the first public notice that we deemed to need a reissuance. Tony Meta, their engineer, updated the plans to include a path around the work area to demonstrate the public access. The reissuance was on August 8th, 2023. Further objections were received, but none requested a third notice. Town of Westerly did issue a letter, and it wasn't also a request for reissuance notice, so we moved on with that. There was objections about failure to describe fully Fort Road. The application received new submission and plans that entered a general path through the work zone. To briefly describe the work zone, it's going to be on land. It's going to be where the dewatering takes place. It's going to be where the backhoes are set in order to pull the material out of the water. This is dangerous for people to be wandering through, so there will be temporary fencing set up in order to prevent interruptions into the work area. That's necessary. It'll be done in the off season, and there remains access around the area, as demonstrated by the plans. To talk briefly about the legality of Fort Road, as stated by Emily Hall earlier, these application ownership and use of Fort Road is being actively litigated. CRMC is not party to this litigation, and per RI General Law 8-14-14, Superior Court has the regional jurisdiction of access, and where the title to the real estate or some interest is divided issue. This is not an avenue. Staff do not consider this an avenue for any discussion about the legality. There was also an objection about proof of ownership for this work being done. The Watch Hill Yacht Club does not own the land that the work's being done. That's the Watch Hill Fire District. The Watch Hill Fire District has given their approval through letters for the use of this area. The tax assessors have issued and submitted with the application. I'm sorry, the applicant has submitted with the application the tax assessor lots of the area, which dictate ownership of the area, of the lots that are being used for the work area. This is how we normally do it. This is a very standard practice, and we've taken that as what is before. Complaints that the area being removed is considered sandy beach. So there's a couple of cubic yards of sediment which has built up against the bulkhead, which leads into the cove. This does not match a definition of a coastal beach. We want uninterrupted spans of coastline that are subject to wave action that lead up to a high point. Sediment that is accumulated, that is constantly shifting, does not meet this definition. Any impacts to public access during this area? As I mentioned before, but I will be direct, this is temporary. This is going to expect to take 2 to 4 weeks at most. As this is standard for the project, it will be done in the off season, which is done in the dredge window, which is not very few people. It's needed not only for the continuing use of the marina, but it's also needed for the public safety during the work time. There was also a complaint about increased vessel traffic. The number of slips will remain the same in the marina. Right now, the slips that are most impacted are the ones closer to shore, which tend to be smaller vessels. Those are still in use, but it's not going to change the number of vessels or change the historic use of the area. To the extent there's any beach closures, it would be for relaying down the sand. Sorry. Oh, there will be no beach closures. To the extent there is any temporary interruption to the beach, it'll be just to lay down the reused material. In conclusion, the recommendation for the reasons here live in that similar projects have been applied for or certain complete in the past is staff's opinion that this application adequately addresses the requirements of the Coastal Resource Management Program. The staff has no objections to the issues of for this project. Standard asset stipulation can be prepared, and the council should the council decide to approve the application.
Thank you. Any questions of Mr. Skenyon from the council?
Quickly,
Done.
Yes.
The sand, how much sand did you say you were removing?
765 cubic yards approximately.
And we don't require that to sit somewhere before we deposit it back on?
We do. Usually it's gotta be dewatered.
And you're gonna do that, so.
Yeah, that's why they have such a like a work area.
Yeah, when I read through it, it just, maybe I read it too quickly, but it sounds like you're gonna take it from here and put it over there.
Yeah, that's the plan.
But you have to like, kind of let it dry out and stuff, and
Yeah.
pick the right time of year, I would think.
Sand's heavy, wet sand's even crazier heavier. So in general, you let it dewater and then you load it in the back of the truck. So I'm sure the applicants can speak more about what they envision the process to be exactly, but usually you let it drain for a couple of days, then you load it up and then you kind of cycle the trucks.
Yeah, but Jeff, we had talked previously after the storms that sand should have been put off to the side until I guess the spring, so that it wouldn't wash back out to sea again. There's no impact of that here.
No, and that was because the winter storms had already come and gone, and the spring was still right around the corner with potential for more storms. So the sand wouldn't have any time to consolidate and do what it would normally do in at that time of year. This time of year, this is the time to dredge, and when there is beneficial reuse of dredge material like we have here, and you can place it on a beach, this is the time to do it.
Good, thanks.
The latest extent of their dredge window is January, end of January, and that's usually before the winter storms. And about it gives enough time for the sand to settle in. So
Any further questions of Mr. Scanlon? Right, please proceed, sir.
Thanks. I'll just have Mr. Livingston, very briefly, just talk about the applicant's use of those docks and why this project's necessary.
Yeah, Josh did tell me to be respectful of your time, so I won't go through the long history. But the club was founded in 1913, but more important to commission is that the first dock was put on site in 1922. And there's been a dock essentially in the same position the entirety of that time. And so over the years, there's been multiple dredging, as you heard from Mr. Scanlon, the most recent in 2007 and 1998. However, if you look back in the records, there's any number of times that we've done this. We use the club seasonally, and the club is used for primarily small sailboats. There are some power boats that come in. We don't really have a marina, if you will, there. Most of the time it's touch and go as people come and go. So from the perspective of the club, this is something that's necessary, and something that's been permitted many times in the past, and we're looking forward to you folks approving it yet again. Thank you.
Any questions of Mr. Livingston from the council? Okay.
Banana?
Thank you. I'll just briefly add a few items that or expand on Justin's summary. So we're dealing with two dredge areas on the east and west sides of the clubhouse. The west side of the clubhouse has what Mr. Livingston referred to as their sailing, where the docks are, where the sailboats are stored during the season. So that area there needs to be dredged because the docks have a tendency, now that we've extended this dredging, that the docks have a tendency to sit on the bottom of the cove. We did identify 2 areas for staging for the equipment to properly dredge the areas in question. And we've also outlined the path, which this will be the travel path of the trucks and vehicles to get to the fire district beach just to the south. Couple of things just to address on the beach area, quote unquote, that was mentioned. It's also an area where there's 2 outfalls, catch basin outfalls, on the east side of the ramp to the clubhouse. With the sediment being built up, the drainage lines are clogged and then floods the parking lot. So in that aspect, it does introduce a safety issue, especially in the wintertime with icing for pedestrians. So this would alleviate that by removing the sediment from those 2 outfalls. During the dredging, we'll have some turbidity curtains that are outside of the dredge area, and that will prevent any sediment from going out into the cove and keep it within the dredging area. And as Justin mentioned, we did take samples of the material, and material that's being deposited on the nearby beach did not have any contamination in it. And I believe I presented that to DEM, both the analytical results and where we sampled the two areas for the dredge. Lastly, all of this is occurring within the permitted marina perimeter area of the club. And everything will be done on landward. Nothing, there will be no barges or anything of that in the water. Everything will be done on the landward side of the seawall. I'd be happy to answer any questions of the council.
Any questions about this? No, none, thank you.
Thank you.
Anything else, Counselor, at this time?
I'll reserve until the end.
Okay. Is there anyone else present this evening that wishes to speak in favor of the application? Is there anyone present this evening that wishes to speak in opposition of the application?
Hello, my name is Matthew Ferraro. It's my first time at a CRMC meeting.
Okay, Mr. Farrar, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and spell it for the record.
Matthew Ferraro, MATTHEW,
Thank you. Mr. Langseth, we'll get to you right after Mr. Ferraro's done.
I'm basically here to get clarification. I'm looking at the application. I didn't really come in as an objector or in agreement. Right now, I'm just trying to make the CRM be aware that there is tidal flooding in that area. Mr. Scannion mentioned that, we've worked out a lot of issues with the submitted application. And, I guess I understand that the fire district and the yacht club are going to be very definite about what they submit. But I just sat through the last discussion about a fence, which I didn't oppose, but there was no discussion of how high the water exceeds the banks of the Little Narragansett Bay. I've been a Westerly resident since 1972, 22 years in the Coast Guard. I did 18 out of those 22 years within an area from Management Point to Watch Hill, Rhode Island. I worked for the captain of the port for 13 out of 22 years, which is an unprecedented amount of time. I can understand and read the harbor management plan. And I think you're overlooking the fact that there's tidal flooding. The fact that the fence was damaged by a storm that was documented in the Sun, that Westerly Sun newspaper in the December storm, that, you have basically the bay flooded right up to the fence. Now, I've been to Watch Hill probably a half a dozen times this summer. I'm seeing flooding monthly. And part of that flooding is not on the east side, which was mentioned. It's actually within the part where you're dredging. So with that said, I would like to clarify in the application that the Fort Road access is listed within the plan as it exists in the harbor management plan. Fort Road access along Fort Road shoreline located off of the bay running along Watch Hill Cove adjacent to shops and cabanas and the pedestrian easement leading to Naptree Point running along beside the seawall as a shoreline path and leading through a posted gate to Naptree Beach. This right of way is heavily used in summertime and moderately used in the off season. What I'm objecting to specifically right now is I'm looking at the site plan prepared for the cabanas. And obviously that right of way and the pathway exists along the seawall. It's mentioned there. But at some point during this project, the path is flooded. You're asking people to walk on the seawall through a flooded parking lot. It's dangerous. So can you stipulate where this right of way that currently exists in the harbor management plan can be redirected during the course of this construction, even if it is for 2 months, even if it is in the off season? I deeply respect the actions of Watch Hill Conservancy, but I hope they're in the 21st century and they're realizing the levels of sea are rising. This is at the forefront in Watch Hill, because the parking lot to the north side of the bay floods routinely. And now I'm finding that this pathway, which is in the site plan, you're going to have people walking through a flooded parking lot. And you're going to prevent the use of a right of way. Are you aware of that? I don't even think Westerly knows what the left hand and the right hand are doing. I hope you come in and supervise coastal access to the degree that Westerly needs it. I'm asking for clarification on the application for the mean, high, and low water elevations, nothing more, nothing less. I would like to hear from Mr. August, Professor August, how many times that parking lot has flooded since December 2023. Are you aware of that flooding? Is Westerly aware of that flooding? That's all I have to say.
Thank you. Any questions of Mr. Ferraro from the council? All right, thank you, sir.
Thank you.
So am I sworn in or do I swear in again?
I don't think I did. I'm sorry. Mr. Langston, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Okay, so we're talking about the condominium association that was created in 2013. And the condominium association runs from Larkin Road and Bay Street by the carousel all the way down to the Mifflin property, which includes the big condominiums of the Squamish Club, and then goes beyond that for a significant amount of space, all the way through the place where we're talking about the fences. Then it goes back up on the bay side and all the way to the yacht club. And then there's three parts of the condominium that are organized: part 1, part 2, part 3, and then there's an unorganized part of the condominium where the fence is. Now, the yacht club has leased number 2 from the condominium association. I'm not quite sure of the boundaries because this is all recent discovery on my part. So I'm not really sure about where all this exists, but it's clear that the yacht club has leased condominium number 2, or at least part of it. And that is where I believe they plan to put the dewatering sand. Now, the condominium association has a stipulation that there will be no parking of hazardous material. Now, I don't know, I couldn't really hear very much with the staff about how they consider that sand coming out of the cove and it's dewatering. Is that in CRMC's mind hazardous material or not? I don't know. He may have addressed that already. I really don't know. But the point is that if that is under the CRMC's rules, hazardous material, it really can't be put there. It's got to be put somewhere else. And other people were talking about the flooding, and I've seen it myself where the parking lot is full and, the water's running up and down the parking lot. That's a fairly common event. But if you get velocity, if you get the tide running over from the beach down, running northwards towards the yacht club, and you get velocity in there, God knows where the sand's going to go. So that's really not a good place to put the sand. But I have one question. I think I know how the sand gets to the pile. I think they probably have some kind of a conduit or a pipe or something that pours the sand there. But how does the sand get from the pile to the beach? Is it put on trucks? If it's put on trucks, why don't you just put it on trucks originally, take it away, dewater it, and then bring the trucks back? I would think that that's a far more practical solution than to put the sand on what other people are saying the right of way is, which could very well be, and it creates a hazard. And I don't know whether the sand, which is from a yacht club, I hear that when you dredge out a yacht club and you dewater, I hear, and that's type 6 water, I generally hear that that's not considered good sand until it's dewatered. Well, if it's not good sand, what is it? So these are the questions in my mind, and I would urge the council to get back to understand what this condominium is all about, because it's not totally clear to me, but there're just red flags all over the place. Get answers to that, get answers to whether they can put the sand there based on a condominium rule, which says they cannot do. We'll go from there, and I appreciate your time.
Thank you. Any questions? Is the line set? Thank you, sir.
Yep.
Please raise your right hand. Do you swear or affirm to, I'm sorry. But yep, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? So help you God.
As always, I do.
Even though you've done it for a previous application, please do it for this one. State your name and spell it for the record.
Anthony Palazzolo, ANTHONY PALAZZOLJR. Even though I've done it earlier, I'm going to provide a disclaimer again, because I always do it to everyone I can find. I'm licensed to practice law in Connecticut and California, not in Rhode Island. I'm not representing any interests here, no clients. I can't because I'm not licensed to practice in Rhode Island. I've done a fair amount of shoreline access advocacy. I've never taken a penny from anyone or represented anyone in any time. As always, I'm here in my personal capacity as a would-be user of the area. Nothing I say here today should be construed as rendering a legal opinion of any kind. I have 4 objections to, very narrow objections to this application, and I believe that all of them can be easily solved by the applicant. So I'll start there. I don't have any problem with the information, the content of the application that's provided. I believe it's accurate. I do, however, believe the application is incomplete. It needs supplementary information. And I believe that this particular plan, although possibly maximally efficient, most cost-effective, most convenient for the applicant, is also the most impactful and intrusive on the right-of-way. I believe that these concerns could be eliminated if the applicant simply chose to move its staging area 150 feet along the seawall, sort of northeasterly along the seawall, and to a further area of the parking lot.
If they do that, they move it 150 feet, it would obviously require some hoses that run from the immediate area of the yacht club. And then do their dewatering on the parking lot, 150 feet away from the yacht club. Now, the reason why that's a particularly difficult area where the sand is, it's right around the yacht club. There is a condominium complex called the Larkin Street condominium. This is not what Richard Langseth was talking about. This is depicted in the application, and the particular layout shows that the distant corner of the Larkin Square condominiums points right to the yacht club and the sand that has silted up. As a consequence, we have an area with broad parking lots to the northeast, broad parking lots to the southwest, and a pinched off point right there between the yacht club and the Larkin Square condominiums. That's where all the problem is. That's where the silting is, so that's where they want to dredge. They put the staging areas and the construction fence all right in that immediate area, and they've effectively blocked all access through the Watch Hill Fire District property by doing that. Of course, the Watch Hill Fire District owns the property adjacent to the yacht club where the staging area is. I do know they've submitted a letter approving of this plan. But the thing is, there are obligations to allow public access through there. And this particular plan blocks all of the access between the yacht club and the condominiums. Now, you might not realize that there's a right of way there because the applicant failed to include it. In particular, I'm looking at the map provided by the applicant entitled Maintenance Dredge at the Watch Hill Yacht Club. There is no depiction of the Fort Road right of way there at all. That, of course, the Fort Road right of way is in the record, been provided. Again, it was designated by the town of Westerly in 2008. No court has ever limited it or eliminated it. The town of Westerly has never voted to limit it or eliminate it. It's still in existence. And yet it's not depicted here at all. The CRMC submittal checklist for marine dredging and associated activities specifically says in pertinent part, to be accepted as complete, an application to dredge must include the following listed below. For all projects, site plans must include the following information. All streets and rights of way within 50 feet of the property lines of the proposed activity with fixed reference points. Clearly says your own application checklist specifically says the applicant has to show streets and rights of ways in their application in order to be complete. So my first objection is that this application is incomplete, the failure to depict the right of way as required by your submittal checklist for marine dredging applications. They can solve that. They can put it right in there. I think one problem is one of the reasons why they didn't put it in is because if you look at it, it'd be very obvious that they blocked the entire right of way. And so, you know, it's just like them, these Watch Hill interests to omit critical information to game the system and have you approve things when you aren't aware of concerns like this. So there's a material omission in this application, and it's the failure to include the Fort Road right of way on their plan. If it were there, you'd see the staging areas block everything. That's why I propose that you move it 150 feet to the northeast. The second objection I have to this application is that it raises questions of legal liability for the CRMC. In my opinion, this is an invitation for the CRMC to violate the rights of the owners of the Larkin Square condominiums under the Fifth Amendment of the United States Constitution. If you look at maintenance dredge, the map entitled Maintenance Dredge at the Watch Hill Yacht Club, you will see that it depicts the Larkin Square condominiums, including the Larkin Square condominiums property line. I believe it's accurate. I have a map from the Westerly tax assessor that agrees with this. This map is accurate. The problem with it is it puts a balloon here which says pedestrian access will be directed onto a sidewalk around the staging areas for safety purposes. They are directing the public writ large to cross condominium property, to leave the fire district property, go onto the private property of a third party all they want. Now, to my ear, that sounds a lot like it violates the Constitution under the Supreme Court precedent of Cedar Point Nursery in 2001, which basically said, if the government authorizes third parties to enter private property, that's a forced physical invasion in violation of the Constitution. This is an invitation for you to authorize the public writ large to go onto the condominium property around the staging area. And let's remember, Gerald Petros, the attorney for the Watch Hill Fire District, just won summary judgment on the Cedar Point Nursery theory against the rack line plus 10 law. He told the judge, the government committed a taking by authorizing the public writ large to enter private property on the beach. I don't see a difference here. They're asking you to authorize the public writ large to go onto the condominium property when the condominium property has not provided any kind of consent for people to do that. Again, they could solve that if they move the staging areas 150 feet up to the park of another area of the parking lot. That pinch off area will be open as it should be because it's a right of way. People can use the normal right of way and they can stay off the condominium property. But you've got 12 owners here of these condominium properties that, you know, may have a problem with you telling people that they're allowed to physically invade their property. According to the Town of Westerly tax assessor, those owners include Lewis, Matthew, and Florence RLTA, Nicholas Associates LLC, 103 Bay Street LLC, Rochelle's of Watch Hill, Holdridge Building LLC, Bennett William, Hoyt Marine, Capalbo Properties, Britton Geraldine MR Trust number 2, Barbara Brandon / Food Dim Kristen JLT, and Anthony Paquette. So I would recommend you speak with Mr. DeSisto of whether it's appropriate to authorize the public writ large to leave the fire district property and to cross the property of the condominium complex. The next objection I have is that I believe that this plan raises concern under state law and town ordinances. With respect to state law, section 11-44-24 reads, blocking or obstructing public rights of way to water. Every person who shall obstruct or block or cause any obstruction of any public rights of way to the water of the state shall be imprisoned not exceeding 1 year or be fined not exceeding $500. I have a hard time understanding how this plan does not violate that state law, given that it blocks the town designated right of way, Fort Road, for its entire width between the yacht club and the condominium, the Larkin Square condominiums. The town ordinance that is of concern is section 86-42, interruption of access prohibited. No person shall block, barricade, or in any way impede the public use or access to designated public rights of way to the water as defined by the RI CRMC or the town of Westerly. There's a town of Westerly right of way that was designated by vote of the town council on October 6, 2008. It's called Fort Road, and this plan would block the entire width of that right of way. It appears to be a violation of that ordinance, and I would suggest you speak with Mr. DeSisto about that. Finally, as I mentioned before, the Watch Hill Fire District requested permission to rebuild their seawall in 1987. They submitted ascent application 87-10-066. It was a special exception application in which they guaranteed that the benefit that it had to provide to the public would be public access through the Watch Hill Fire District property. So in my opinion, that fire district property is encumbered by the stipulation Q of ascent 10-066. They don't have the ability to grant permission while also blocking access. The stipulation that was granted expressly stated, quote, pedestrian traffic to Nappertree Point shall not be restricted, close quote. Their property is encumbered by that. That's what it took in order to build their seawall. That was the exchange, the bargain between the private entity of the fire district wearing its private hat and the public writ large. And the CRMC did a damn good thing in getting that stipulation Q. And here, it's totally ignored. It's impossible for people to walk from Bay Street to Nappertree Point when the staging area is there and there's construction fencing. It's entirely blocked. Stipulation Q is violated. Now, final point about this is there is a lawsuit and it does involve Fort Road. The Watch Hill Fire District sued the town of Westerly, DEM, and a number of property owners. But that has nothing to do with stipulation Q. It should not impede your ability to reestablish, affirm the viability and enforceability of stipulation Q. I have a copy of the Watch Hill Fire District's complaint right here. There are 4 causes of action, 4 things they're complaining about. None of them even mention ascent 87-10-66. None of the 4 causes of action say anything about the stipulation Q. It's not a part of this lawsuit. Indeed, the CRM, as Emily Hall told us earlier, the CRMC is not a party to this lawsuit. They couldn't be seeking to invalidate stipulation Q because you are not the defendant. The word stipulation is never even used once in the fire district's complaint. Maybe they have a point that there is litigation over Fort Road, and that's one of the objections I have here. But an independent objection is that this property is encumbered by stipulation Q, which says that pedestrian traffic to Nappertree Point shall not be restricted, and here it's eliminated. It's blocked entirely. So finally, all of these problems can be solved if they move their staging area 150 feet along the seawall to a distant corner of the parking lot. And that's what I would suggest you demand of them, and include the Fort Road right of way in the mapping. Now, when they put the right of way in there, if it makes them feel comfortable, they can put a note. Westerly asserts this is a valid right of way, but we disagree. That would be okay with me too. If you have any questions, I can answer them. Otherwise, I just thank you for your time.
Any questions of Mr. Palazzolo?
I just have a quick question. Mr. Palazzolo, are you familiar with Larkin Square condominiums?
Yes.
And the list of owners that you gave us made it sound like it's a commercial condominium. Is that correct?
I don't know about any commerce associated with the condominiums. The one thing I could say is that in looking at various property records throughout Watch Hill, it seems that most of them are technically owned by LLCs or corporations. And of course, you know, that may be due to tax consequences and such.
But are you familiar with the structure, Larkin Square condominiums?
I am and have been for 50
So
years.
are there businesses there or are there no businesses there?
There are some businesses on the ground floor.
Okay.
of that building.
Okay.
And then above there are residences.
Okay. Do you know if there are any restrictions or prohibitions on what people frequent the businesses?
I'm not aware of that.
All right. Thanks.
Well, the only other thing I could tell you here is that, I've looked at the record and I haven't found any letters of consent agreeing to allow pedestrians seeking to, reach Nappertree Point to cross their property.
There's no prohibition about it either, is there?
You would have to ask Mr. DeSisto if that's relevant.
Thanks.
Any further questions of the witness? I thank you,
No,
sir.
but before you go, can I get a copy of that complaint?
Sure.
Thank you.
Anyone else that wishes to speak in opposition of the application?
It's already passed.
That's right.
Oh, I beg your pardon.
In opposition, am I okay? I raised my hand and
Yes.
I just sat.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Please state your name and spell it for the record.
Joy Cordio, Joycordio.
Ms. Cordio, please continue.
Okay, so I'm here, I am a Westerly Town Councilor. And the council, I believe in 23, first voted to object to this application for one reason only. And that was because the applicant failed to fill out the application according to the CRMC checklist guideline. That's it. That is it. I don't care about litigation. You do have a letter from the town manager that was submitted August 24th, 2023. Because we are actually in litigation, I would respectfully request that you hold off on a vote on this issue tonight because the town solicitor is not present. And that's my request.
Thank you. Any questions of Ms. Cordio? Well, thank you.
Okay. So does anybody want a copy of the letter? No?
Yes, please.
Does anyone else wish to speak in opposition of the application?
That's what to Mr. Porter.
Maybe he doesn't. Of any of the.
Okay.
Okay.
Go first, I'll pat.
Okay. Council, please.
Thank you. And again, it's Joshua Parks on behalf of the applicant. I'll be brief in my comments. I just want to take the last objection first regarding the request to hold this matter. This is a properly publicly noticed meeting. We're here. I've not seen any request from the Westerly Town Solicitor that this should be postponed. So I think we're probably here for a decision tonight, and I think the council should. The objections, much like from the prior application, are really centered around Fort Road. And that's not why we're here. We're not here on an application concerning Fort Road. We're here on an application to conduct maintenance dredging in much the same course and fashion as has been happening at this property, at this site, in the same manner for the past approximately 40 years. Submitted with the application materials, you saw a sediment sampling plans. This is all, the sand has all been tested appropriately. It's all safe sand. As Mr. Scannion mentioned, it's sand is going right back from whence it came, essentially. We also included comparisons to, I believe, the 2007 and 1992, two of the several previous dredging operations. We compared to that sediment, and it's much. There was an issue raised regarding tidal, regarding flooding. If anything, it should help alleviate that problem. The sediment is building up against the seawall, which forms the north end of that parking lot. As Mr. Nena testified to, there are two outfalls there. To the extent we get sand away from those outfalls, that should hopefully relieve any area of flooding. The objections also talked a lot about fire district. I just want to make sure we're not conflating various applications, condominiums, property owners, what have you. This is the Watch Hill Yacht Club's application to conduct limited dredging wholly within their marina perimeter limits. I also want to address the suggestion that this would all be fixed if the yacht club simply moved its upland dewatering plan to the north. The dewatering is taking place directly on the landward side from where the dredging is going to happen. As Mr. Nena told you, this is happening from the landward side. This isn't something where you're bringing in, barges and tugs and what have you. It makes the most sense to pump out dewater directly on the close access point, and then once everything's dried out, you put the sand in the trucks, you drive around, and it goes onto the beach facing the Atlantic Ocean. And really, I think that addresses the sum and substance of the objections. I'm happy to answer any questions that the council may have.
Any questions of the attorney?
Yes. Do you know how long the dredging operation is going to take from beginning to end? And when it's going to start and when it's going to end?
Mr. Nana can correct me if I'm wrong, but I believe it should take maximum of approximately a month.
Probably less than that, but yeah.
Probably less than that. And the dredge window is in the off season. So this is happening, it's not happening 4th of July, it's not happening Labor Day weekend. It's also not happening when there are lots of people around in that parking lot. And I was remiss in not addressing the public access component. This went to CRMC, and a conversation happened between staff and Mr. Nana regarding ensuring there was public access around the surrounding area. Hence why on its sheet 5 of the resubmitted drawings, you'll see the plan which provides for construction fencing, so you don't have people where the excavators and dredge equipment is for this limited window. And they can still safely walk around the parking lot, and then they're directly back on the seawall on each side of the area.
Does any of the work impact this Larkin Square condominium property?
I don't represent Larkin. I can't pretend to, but all of our operation is happening on, the dredging is obviously happening in the water. The dewatering is happening on Watch Hill Fire District land. To the extent public ends up walking on that concrete walkway that's between the Larkin condos and the north side of the harbor there. To the extent people want to walk on the publicly accessible walkway, that's fine. I'm not aware of any objection from anybody at Larkin. I don't think anybody's here tonight in that capacity.
I think those are all the questions I have. Anything else from the council? All right, thank you, sir.
Thank you.
I just want to, Mr. Scannion, has your opinion changed based on any of the testimony or evidence that's been submitted here this evening?
No, it has not.
Mr. Flynn.
Just a question for Mr. DeSisto. The proposal has made a contention that if this plan is approved, we would tacitly be telling people that it's okay for them to trespass on private property. Is that's pretty
No, I
clearly saying.
actually don't agree with that. I don't see it as a constitutional violation. And by the way, I understand why Mr. Izzy asked the question. There's businesses there and the public, there are invitees. Even if that weren't the case, that's not part of this application. I had a chance to glance at this lawsuit. And I do think it's proper for the Superior Court to determine, A, the existence of Fort Road, and B, if there is Fort Road exists, where it exists. That's properly before the Superior Court under 8-2-14. It's a declaratory judgment action. And I think that it's in the proper form right now.
But I think this question is a little bit different.
But yes, I understand what that is, but here's the point. That assumes that there's a Fort Road. That assumes that the Superior Court is going to make that determination. That hasn't happened yet. So I think that puts the council in a position where they have to make that determination ahead of what the Superior Court is doing with this discovery going on. I noticed in some of this that somebody had engaged a surveyor on this. That hasn't been presented here. So that's not something that you have before you. Where's the backstop for that? Even for this condominium, even for the parties to the case, one of which is the town of Westerly, if this application is to be approved, if it is to be approved, and this is to go forward, there's always the opportunity to ask that an injunction be issued against the applicant from going forward on this in Superior Court. That's where it'd be properly had. So I think what you need to do is take a look at what you have before you in terms of the staff report and what you had presented to you tonight and make that determination. Many of these issues really going to have to be sorted out in Superior Court and perhaps even the Supreme Court too.
So you would suggest that if the Larkin condominium owners had an objection that what they should do is seek an injunction if this were to be approved.
Oh, no, it would be others that would have rights under this lawsuit. That's the first thing. The second thing is the suggestion that somehow an action by the CRMC would be unconstitutional. And, you know, I mean, what Mr. Palazzolo referenced was the Stilts case. That was a determination as to whether or not a statute passed by the General Assembly violated the Constitution. I don't think that's applicable here. I am not concerned about any liability for any action that CRMC would be taking here. And again, you know, there's an existing case, which is a vehicle, and relief can be had at that level. But you have to take a look at what's before you and make your determination.
Just a comment. It appears we're talking about a month's worth of time. That's the test. What's the, you know, and it's off season and all these other things that I heard tonight about when it's going to be done and how it's going to be done. I just don't see an impact. You know, anybody that's going to be walking around down there at that point in time I would think would be perfectly happy to walk around. You know, it's not the 4th of July. That was set up with families and things like that. So it seems to me we're spending an awful lot of time trying to find fault with the presentation, the staff report, when we're talking about a month or less. So that, you know, over and done with before anybody can sign a paper.
Okay. Is the council in a posture or position to make a motion?
Mr. Chair, I would move approval of the application with the standard stipulations as described by the staff report.
In the findings of fact based in the staff report too.
Yes.
Mr. Gagnon has made a motion to approve. Is there a second? Seconded by Mr. Gomez. Any discussion? Hearing none, I'll poll the council. Mr. Flynn.
Aye.
Mr. Izzy,
Aye.
Mr. Gomez,
Aye.
Mr. Russolino,
Aye.
Mr. Gagnon, Ms. Reynolds.
Aye.
I too, Raymond Coy vote aye. The application has been approved unanimously.
Thank you.
Thank you.
That's the difference, Johnson.